All right, in this video, we're going to talk about 5 different ways you can avoid going to jail if you find yourself charged with a crime. You know, getting arrested, going to jail, and facing criminal charges is one of the scariest things a person can have to face. And if you find yourself in this situation, it can be very overwhelming, but this information here might give you a bit of peace of mind. My name is Jamahl Kersey. I'm the principal attorney at Kersey Law. We're a boutique criminal defense firm in San Diego, California. And again, in this video, we're talking about 5 different ways to avoid jail if you're charged with a crime. So number 1 is going to be showing that you didn't actually do what you're being charged with. Believe it or not, there are times in which somebody might get arrested and facing criminal charges for something they didn't actually do. This comes up a lot in domestic violence cases. There are a number of reasons why somebody would make up a domestic violence situation. It could be out of spite. It could be to get a leg up in a custody battle. Whatever the reason is, basically, we would want to do our investigation in order to expose the lies and demonstrate to the prosecutor that you did not do what you're alleged to have done. And if we're able to sufficiently demonstrate that, then that's going to be a surefire way for you to avoid going to jail. The second one is going to be showing that the offense is not as serious as it was charged. So this isn't going to be a situation where you're trying to say you didn't do anything at all. You're just saying I did something, just not to the extent of what I'm being charged. So the charges they may have filed against you might carry jail time with it, but if we're able to demonstrate, let's just say in a violent offense, that the injuries weren't nearly as serious as were originally reported or as the police had put in their report. Maybe they put that the alleged victim suffered some very serious injuries, but it turns out that the alleged victim denied hospital treatment. They denied going into the ambulance. They actually wrote back to the DA or response to the victim's advocate and said, oh, my injuries weren't really that bad. So if we're able to demonstrate that the injuries were not nearly as bad as the DA originally contemplated, then that can be a way to avoid going to jail. Number 3 is going to be that you did it, but there's a story behind it. So in this situation, for example, we had a client who was stealing from his employer. He sincerely regretted it. Unfortunately, he fell on some really serious hard times. It's no excuse, but it was the reason why he stepped outside of his own good character and stole from his employer. And we had a bunch of letters of support speaking to this guy's good character. He wanted to join the military. He wanted to serve his country. He was in school. We were able to package up all that information. And while it was an offense for which he could have gone to jail, the DA was understanding and saw that, hey, this guy does have a really good character. He wants to do some amazing things in the future. He's got an education. Putting him in jail is just going to derail all of those plans. So we actually got that case dismissed. Number 4 is going to be you did it, but it was legally justified. This is going to be your self-defense theory or your defense of others theory. If you're in a situation where somebody places you in fear of immediate bodily harm or death, then you are able to respond with force to defend yourself. In California, you don't have a duty to back down and retreat. You can use force. So if you're defending yourself or defending someone else or defending your home, right? An intruder breaks into your house and you end up shooting them, then yeah, maybe you end up killing that person, but you're acting in self-defense. So you're saying, I'm not denying that I shot this person, but I was acting in self-defense. Therefore, my actions were justified, and therefore there should be no conviction at all. The last one is going to be showing that the cops did not play by the rules. Listen, cops have rules to go by. They can't just search anything that they want or search anyone that they want. Generally speaking, the cops need a warrant in order to search your car or your home. If they search your house or your car without a warrant and there's not an exception that applies in the situation, because there are exceptions to the warrant requirement, if none of those apply, then that might be grounds to challenge the search. And if you're successful in challenging the search, then under the exclusionary rule, that can be a way to get the evidence against you thrown out. So that may mean that you did something wrong, but because the police did not play by the book and they violated the law, that can result in you avoiding jail time. So those were 5 different ways that working with your lawyer, you can avoid jail time. Whether you can use one or more of them is really going to be determined on a case-by-case basis. It's going to come down to you sitting down with your lawyer and your defense team and going through the evidence and forming a defense strategy in order to put you in the best possible position for a favorable outcome, which ideally avoids jail time. I want to thank you so much for watching, and until next time.